I'll connect by phone.
Okay. All right. Are you reconnecting?
Yes, sir. I'm calling in right now.
Okay, we can hear you fine now, so maybe it was just the
Oh, okay.
All right, let's go ahead and go forward with the hearing. You may proceed.
Okay. Do you have a preference on which motion to quash we deal with first, Your Honor? We're dealing with 3 of them.
All right, just whatever one was filed first.
Okay. I believe the first one was on the, I believe it was the Blue Cross Blue Shield record. So the defense sought basically everything conceivable on Blue Cross Blue Shield records for the plaintiff. I apologize. I'm having issues logging into my separate deal to go through the language, but it was basically everything in the kitchen sink. The one thing that we were highly concerned about, Your Honor, is although understanding the case law that's cited, that more and more we're getting into this discussion on getting with health insurance rates and things of that sort to get, every claim for the plaintiff using her health insurance without limitation on whether it has to do with treatment to the same or similar body parts. We get into obviously concerns with HIPAA and physician-patient privilege, as well as mental health privilege. Just because a plaintiff files a lawsuit does not mean that she opens up every aspect of her life in every regard. And when we get into health insurance contracts, things of that sort, that is a big concern. And I apologize that I just can't, for some reason, I cannot get into my system and pull up the motion. But that was the problem with it, was basically over breath, fishing expedition.
So there's a recent case out of the Supreme Court. I think it's auto crushers. Is that what it is?
I think there's auto crushers, and then the defense cites, I think, an even newer cases, which is the In-Ray Exxon Mobil Corp or something to that extent.
I haven't read that one. I've read auto crushers. I actually had an intern do a memo for me on it. But what does In-Ray Exxon do? Because I haven't heard that one. I haven't seen that one.
They basically take the K&L Auto Crushers opinion and say there is still a need to look at the proportionality to the case, meaning with auto crushers, there was like 1.2 million in past medical that was submitted. So that is something to be looked at. I believe K&L Auto Crushers starts with something to the extent of reimbursement rates may be relevant, although not conclusive of what a reasonable charge would be, reasonable cost of expenses would be. And then they go into an additional analysis, basically saying, the defense can't prepare without it. And there was basically a mandamus proceeding.
Okay. Mr. Matthews?
Yeah, so just to address the K&L Auto Crushers, In-Ray Exxon Mobil, these are all cases following in the footsteps of In-Ray North Cyprus.
Right.
And in that case, that kind of started all of these cases in which they allowed this information to be discoverable in the first place. The reimbursement rates from various insurers, Medicare, workers' comp, things like that. And specifically to all of these hearings this morning on our motions to quash, the amount at issue in In-Ray North Cyprus was around $8,000 to $10,000 is all that they were arguing in that case. And the court still found the information to be relevant and proportional in that case. In In-Ray K&L Auto Crushers, admittedly, the amount at issue was 1.2 million. But in that case, the Texas Supreme Court reiterated, we also already found the 8,000 to be at issue in In-Ray North Cyprus to be proportional for that discovery as well. In In-Ray Exxon Mobil Corporation, the amount was even larger than In-Ray K&L Auto Crushers. It's in the millions because that was a result of a refinery explosion. So there were many, many claimants. And again, the Texas Supreme Court reiterated, we've already found this discovery to be relevant and proportional, even in an amount of $8,000. So to the extent the plaintiff in this case isn't seeking $1 million, the court has already held as a matter of law that this discovery is proportional, even for $8,000 at issue.
Mr. Rodriguez?
Yeah, quick rebuttal on that, Your Honor. I do not agree that North Cyprus went to the extent the defense says. North Cyprus was a hospitaling case where they said reimbursement rates may be relevant. And that's how it started with that analysis. And yes, it was a lot lesser amount. KNL Auto Crushers comes in, and then we look at ExxonMobil Corp. ExxonMobil Corp still says that there has to be a look at whether it's proportional to the needs of the case. To my knowledge, and I'll reread both cases, but to my knowledge, neither case says because North Cyprus said what it did, which again, it was a very refined issue there, was not the same issue we have at Bar. It was a hospitaling case. Nothing.
Are any of these cases involving, so you're trying to get discovery from the plaintiff's health insurer, right?
Yes, Your Honor. And we're to a certain extent, there may be a commingling of issues here. A lot of this is more directed towards the momentum spine and joint DWQs. But our position as to Blue Cross Blue Shield, even taking out of the equation the KNL Auto Crushers analysis, the fact that plaintiffs had health insurance at the time of this accident, we're certainly entitled to know that, certainly entitled to know the length of time that she had that coverage, whether any bills were submitted, if they were
so did the health insurance not pay for any of the bills?
I don't believe that there was any bills submitted to health insurance, Your Honor.
Which would include the ER did not submit them either. They submitted them to the liability insurance.
So INRAE, so I don't know how INRAE Auto Crushers, how does that even apply? Because those were all bills that were submitted, weren't they? Or am I wrong about that? No?
No, Your Honor. In all three of those cases, the issue was that these medical providers, just because they charge something for a procedure, that's not indicative of what a reasonable amount for that procedure is.
I guess what I was saying, I didn't say that very artfully. I apologize. In those three cases, it was discovery against the medical provider, not discovery as to the health insurance, correct?
That's correct, Your Honor.
I believe so.
Okay. All right. So I'm going to grant the motion to quash as to, well, I guess there's also the issue. You want to find out if there was any treatment to the areas of the body. What I typically do in this situation is if you want to have do the DWQ, have it go to the plaintiff's attorney. I have a very standard ruling on this, which is any treatment to the same area of the body claimed in this case, you can discover. Any treatment after the accident to the same area of the body, even if it's from something unrelated, you can get. Anything else you can't get. So if you want to, request that, have it go to Mr. Rodriguez, Mr. Rodriguez would turn over whatever he thinks is appropriate. And then if you have some kind of issue with it, then you request an in-camera review.
And Your Honor, we have no issue with that. And I'll admit that the DWQ is broad in terms of lack of limiting language. And we're certainly not against, appropriate limitations on that, such as what you've mentioned. So I'm perfectly fine with that.
Mr. Rodriguez, why don't you prepare an order as to that? We'll go to you, you review it. We'll go through this whole process. I'm sure you have a standard order on that.
Yes, Your Honor. Can I just clarify one thing real quick?
Sure.
How far back is the request allowed to request? It's a fairly young plaintiff. I think she's in her mid 20s-ish.
To 5 years prior to the accident.
5 years prior. Okay. And so basically we're going to refine the request. So it's requesting specifically treatment 5 years before to the present for same or similar body parts.
But I will say, but you're having a billing clerk at the health insurance. I want it to go to you first so you can look at it, make sure it's properly done. But however you want to refine it, I'd rather go to you first just to make sure they don't turn over stuff that's not supposed to be turned over.
Okay, that sounds good. We'll get the order prepared.
Let's say you'll have a week to look at it and make a determination.
Is it okay? Fair enough. And if we need to extend that out a couple of weeks, if defense counsel is okay with that, is that all right?
Perfectly okay with me.
Okay. All right. Sounds good.
What's the other issue? You said there's a couple medical providers too.
There's one specifically on momentum. And so specifically, you know, a lot of it has to do with, and again, I apologize to the court that I can't pull this motion up, but basically there's several questions. It goes into health insurance rates for various health insurance companies, including Blue Cross, which is the one at issue, but also United Healthcare, other ones. I think it goes into whether there's a cash pay rate. It also goes into collections under LOP. And so the one thing that, you know, when we're looking at all this, again, it's still a proportionality analysis, but none of the cases that I've seen go into collections. There may be requests for, hey, we need to know the health insurance. What would they pay Momentum Spine and Joint for this plaintiff? I don't know if it, you know, going outside of that on what they take for other health insurance companies is, or Medicare, Medicaid. You know,
what my thought is, and this is not a ruling yet, but this is kind of where I'm heading, is my recollection from NRA Auto Crushers in Cyprus. I have not looked at this Exxon case. Is there was a standard kind of, I remember, and I think I remember in the NRA Auto Crushers case that there was some standard discovery that they allowed in both those cases. And my recollection is, and again, I may be wrong about this, is that the basically in NRA Auto Crushers, they basically affirmed that whatever was requested in the Cyprus case was appropriate. Have you guys looked at what that is exactly? I haven't had this come up in a hearing before.
Yeah, yes, Your Honor. So in NRA North Cyprus, and then basically, like you said, reaffirmed in NRA K&L Auto Crushers, it's specifically what's mentioned is reimbursement rates and documentation regarding that. As far as the particular plaintiff at issue, which ours are limited to this plaintiff, and limited to the specific services that were provided to the plaintiff, which again is what ours are limited to in this circumstance as well. And I will preface that by saying, as far as the private insurers and secondary payers, that's the information that we're seeking. There are some additional DWQs that don't pertain to those reimbursement rates that we still contend are applicable for the same reasoning that the reimbursement rates are.
I'm only going to allow what was allowed in NRA Auto Crushers or Cyprus. Nothing beyond that. I'm not going to expand the scope. So whatever was allowed in those cases, that's it. I'm not going to allow anything else.
Sure.
Okay, and we can get together on the case, and I mean, whatever, you know, whatever the language was, it was. So I'm sure we can craft an order to that extent, Your Honor.
Okay. Anything else, guys?
Yeah, just one last one. I'll keep it real brief. So we also sent some requests for records. So the defendant at issue, a truck driver, we got his application. He had a few prior jobs, I believe. The company in question that we're seeking, Seagate, he worked there about 2016 to 2018. Some of the information we were able to pull up, it looked like he had some hours of service violation for driving over the 11 hours or whatever it is. And then he had a wreck there. It was a one vehicle wreck where I think a tire popped off or something. So we are seeking items regarding his employment there. Apologize that I can't pull up the list, but it's basically what the trucking company has to review on whether they're going to hire him. So it's going to be things like drug tests, discipline, application, road tests, things to review to see if he had any problems there. We have made a claim for negligent hiring, retention, supervision, claims against the company, and we would argue that those items are relevant on what we're seeking. The list was longer than that. I just apologize that I can't pull it up right now.
Yes, Your Honor. So this particular employer at issue, our driver stopped working for them over 2 years prior to the current accident and the current employer that he's working for today. Even with negligent hiring, negligent entrustment type theories, I don't see any way that his employment records from an employer 2 years prior to our accident has any relevance at all.
Wouldn't it go potentially at least go to the issue of negligent hiring?
But, and Jan, I see your point there, but even all of those documentation that they're seeking, that's not something that would be provided to the current employer when they hire the driver. The driving company at issue runs their own background check, and they have to submit to an application, verify prior employers. But even in that prior employer verification process, in no way do those prior employers send over all of this documentation. It's a standard form issued by the FMCSA that asks, what did this driver drive for you for this period? Did he fail drug test? Was he a competent driver? And that's all that's required under the regulation. So to the extent there's all this information from a prior employer, there's absolutely nothing in the regulations that would require the current employer to go and get that information outside of normal background checks, which were done in this case.
Well, in our argument would be it may still be relevant what's there, despite the fact that the company may not have gotten it. I have truck drivers all the time that, based on their record and other tickets that they've gotten, that stuff comes up, even if it's not within that 2 to 3 years. And I think the look back period's 3 years, not 2 years, for required for employers. But again, it's certainly within the scope of discovery. It may not be admissible at trial, but it's within the scope of discovery. It's reasonably calculated.
Motion to quash is denied on that one. All right, so guys, go ahead and get me an order on this. When you prepare the orders, and I don't care who prepares them, make sure it says at the beginning that this hearing was held on February 14th, 2022, and it has a little heart next to it. I'm just kidding. Just kidding.
I'll make sure that happens.
Just kidding. It's only a joke. But just go ahead and prepare that. Go ahead and turn that over to share it with the other side, and then go ahead and submit it to me as soon as possible. It would be great if I could get the order before Friday. So I've had lately some people who submit the order a month or two later, and it just makes it harder to process. So you can get it to me by Friday. That would be great.
Yes, Ron.
Yes,
all right, guys, you guys be safe and have a great day. Okay.
Thank you. You too.
Thank you. Bye-bye. Okay, our next hearing, I believe, is everyone here on the, I don't know how to say this name, GRC Dallas Homes LLC versus Rusam. Are all parties here for that?
Your Honor, this is Fibbins Crunton, and I'm here for the defendant, Jane Bono. I don't know if the other gentlemen are on here yet. I'm trying to turn my video on too.
Is there anyone else here on that case? I see somebody's phone number with a phone number. Is that you, or is that your client, or?
No, Your Honor, that's neither one of us. So I understand that the plaintiff who filed the TRO as of last night was seeking to either postpone it, but he sent an email to Ms. Pinson. I don't know if that's been dealt with in terms of being addressed.
I don't know. Ron, did you get an email? I don't have an email. I'm just looking right now.
Yeah, I think you were copied on it, but I don't know if
wait, was this the one where he said he took it down because he looked at your response?
Yes, that was
okay.
90.
All right, yeah, I do have that one then.
Okay.
I thought that was something different. And there's a letter.
I tried to reach him this morning by phone call, but I didn't reach. I guess he probably wasn't at the office at the time, and I've emailed him earlier as well, but I haven't had any response yet, Your Honor.
Okay. Well, then I guess this one's canceled. But there's somebody just trying to sign on. Let me make sure it's not. There's the same person trying to sign on.
Yeah, that's him. I just got an email from him that he's trying to get back on. So he must have been on here at some point.
Sorry about that, guys. I didn't know how to unmute the mic.
Who's this?
This is Ryan Ruse, attorney for plaintiff.
Okay. I understand that you had canceled this hearing.
Well, I was requesting from, I was trying to reach out to Mr. Fibbins last night, but I don't think he was wanting to agree to postpone it. He just wanted to he wanted me to either cancel or proceed with the hearing. So I guess we'll just proceed.
Okay.
Well, wait, so you're not canceling the hearing?
I'm not canceling the hearing, Your Honor.
And Mr. Fibbins, or I'm sorry, Corin
Clinton, yes, Your Honor.
sorry about that. You don't want to just delay the hearing?
Your Honor, what I asked was, and I asked by email after I didn't reach Mr. Ruse this morning, that if he wants to take it off, then he should withdraw his application for now. He can refile it and then we can take it up. But I didn't want to just kick the can down the road, only to have to get up and prepare and do, because I had to move stuff around today to do this. So if he wants to withdraw his application and refile it at some other point, that's fine. If the court wants to postpone the hearing, that's fine. But I guess I was trying to figure out what the postponement was going to be for, and if that's something that we could have addressed. So,
well, what I'm gonna, the TRO, the motion that I have right now is more of a bludgeon. It's a hammer. I was gonna go back through and after seeing your response, maybe use a scalpel instead, so to speak. So instead of asking the court to prohibit the defendant from performing any type of construction on the property, I think it would be more appropriate to continue to allow the defendant to do any kind of construction, but instead of, I guess, to ask the court to prohibit her from getting any type of liens or encumbrances on the property. So if she wants to proceed with construction and make the payments out of pocket, that's fine. But, I think if, we have some time to, maybe you and I discuss what the type of expenses are, what the, if she has money to proceed with construction out of pocket, then, maybe we could reach an agreement outside of court.
Mr. Ruse, I think, but that's what, that implicates the substance of her response, which is that she's already gotten a loan and she's already had granted some sort of lien on the property in order to get that loan. And so, I mean, at this point, I guess, I don't know.
So it would just be, if there's a loan on, or if there's a lien on the property already, then it is what it is. But, any additional liens on the property, that's what we're going to be asking the court to prohibit your client from doing.
It sounds like, guys, I don't need to be here for this. Why don't you guys try to work this out? If you can't work it out, new hearings that, wait, Mr. Pema, is he on this case too?
Mr. Pema is on, but I don't think that he's on the call right now.
He just joined us.
Okay, here we go.
Okay, Mr. Pema, did you want to say something about all this? Apparently, I thought this hearing was canceled, but now we're talking about stuff. Mr. Pema, are you there?
Michael, you might be on mute.
If you're on mute, press *6.
I got it. I apologize, Your Honor. I got an email. I saw the email early this morning that's been canceled. I do have my tie and a jacket back here, so I do apologize for not being properly dressed.
That's okay. No worries at all.
But it was my understanding that it had been canceled, and I think the email says, please take us off the docket. So.
Yeah, that's what I understood too. So I think in all fairness to Mr. Pema, at the very least, that we should go ahead and reschedule this hearing or cancel it, because I understood it was canceled, and it's not fair to Mr. Pema, who understandably thought it was canceled too, that we just restarted up again. So
right, Judge, I have no objection to postponing or canceling this hearing, so long as if you know, I'm going to try to work things out with Fitmans, and if we're not able to reach any type of agreement, then if it's okay with the court, I'd like to either amend or, you know, just refile the TRO.
I have no objection to that, Your Honor.
Okay. All right, guys. You guys be safe, okay?
Thank you, Judge. Again,